broadcast. Computer's really slow right now. Actually, I'm going to share your screen in just a moment.
Okay. Are we getting people in?
Yes. So we have about 16 right now. So we're going to go ahead and get started. I want to welcome everyone to the webinar, ABC in the Shutdown, All Things Liquor License. It's presented by the Temecula Valley Chamber of Commerce. Before we begin today, we have a few Zoom reminders to make this an effective meeting for all of us. The first is we encourage you to ask questions. Please use the Q&A box on your screen where you can submit a question. It should be on the bottom of your screen. The second is you will all be able to see the presenter. We can't see you. Now, I would like to welcome our presenter. Michael Brewer is the president of the Alcoholic Beverage Consulting Service, California's leading alcoholic beverage licensing firm. Alcoholic Beverage Consulting Service represents numerous alcoholic beverage licensees in all segments of the alcohol industry, including international convenience store companies, national restaurant and hotel chains, regional supermarket and drug stores, as well as local restaurants, breweries, wineries, and wholesalers. ABC's has managed over 7,000 California and federal alcoholic beverage licenses and permits applications. Mr. Brewer is also the co-founder of License Locators, one of the California's largest liquor license brokerage firms, and California Business Escrow Incorporated. In addition, Mr. Brewer has been a guest lecturer at the San Diego State University, the Escrow Training Institute, the Escrow Institute, Los Angeles Escrow Association, and California Association of Business Brokers. Prior to joining ABC's, Mr. Brewer was a regulatory auditor for the United States Customs Service and holds a master's degree in accounting from San Diego State University. Mr. Brewer is an associate member of the California Restaurant Association, California Beer and Beverage Distributors, National Association of Licensing and Compliance Professionals, and the National Conference of State Liquor Administrators, and its founding member of the Alliance of Alcohol Industry, Attorneys and Consultants. Mr. Brewer lives in Temecula, California with his wife and 3 children. Please welcome Michael Brewer. Hi, Michael.
Good morning, everyone. I'm glad to be able to help you out in these interesting times. Thank you for taking the time to join us this morning to talk about COVID and the ABC. As you see the title, The Good, the Bad, and the Ugly, I think that speaks for all of us. One thing that wasn't mentioned in my bio is that I also own on-premise establishments. I own 3 bars located both here in Riverside and in Northern California. So I'm in the thick of this with all of you as well. And so I definitely am feeling the frustration, pain, and all the things that you guys are going through. A couple of caveats as we get started on this presentation. I wanted to mention that this is not legal advice. It is good, you know, it's based on sound things that I've gotten direction from ABC and from others and my experience, but I want to make sure if you're going to take a particular action, if you would contact me offline or consult with your attorney, or I can put you to an attorney if there's something that you're super concerned about. In addition, I want to make sure that you understand that I'm only addressing this from an ABC compliance perspective. I'm not concerning myself with the Department of Health, like Riverside County Health Department. I'm not concerning myself with Cal OSHA, and I'm not really talking about issues related to insurance or other compliance matters. I'm only looking at it from an alcoholic beverage control perspective. In addition, I want to remind everybody that this is being recorded. So I will be, I don't want to call anybody out. And if somebody identifies the restaurant, I'll try and speak with them generically and not mention your location, so that if you are doing something that might not technically be in compliance with the law, I don't want to get you in any additional trouble. Finally, I am not a representative of the Alcoholic Beverage Control. I do not work for the California Alcoholic Beverage Control, and the opinions expressed in this venue are those of myself and only me, and do not represent the government in any way. With that said, let's move on. I want to go over the stay-at-home order a little bit briefly with you. That'll be my slide number 3 in the presentation, because we're going to be talking about it later. I know most of you have already seen the stay-at-home order, but when we start talking about potential workarounds later in the presentation, we want to be cognizant of what the order is and who's ordering it. It is coming from the public Director of Public Health. The California Department of Public Health is who actually issued the stay-at-home order. There are very specific things that they created in the stay-at-home order. One, that all gatherings with members of other households are prohibited in the region. Of course, we all know Riverside County has already met the less than 15% ICU capacity. I heard this morning on the news that I think they said LA County is down to 3% capacity for ICU beds. So we're well, and since we're lumped in that same region, we're severely in the lockdown. And while they said it was going to be initially 3 weeks, I'm already hearing rumblings that everybody's anticipating it going much longer. With that said, it's important to notice some of the language they use. There's like subsection C, worship and political expression are permitted outdoors, consistent with existing guidance for those activities. That'll be something we'll be talking about a little later in the presentation. And also critical infrastructure sectors may operate and continue to modified conditions pursuant to the applicable sector guidance. And there's some other issues with workarounds related to that'll be talked about. That said, basically we're all shut down right now, and none of us are supposed to be operating except for certain exceptions. One of them in the order is retail. Retail can still continue to operate at 20% capacity, and that'll come into play if you're exercising your off-sale privileges of your licenses. So I wanted to call that out, and we'll get into that in a little more detail in a few minutes. They're pretty, extensive here. They're prohibiting overnight stays at campgrounds. This order, is pretty extensive, and it's pretty draconian in my view, but it is, even lodging establishments and restaurants. Lodging establishments are only supposed to be providing accommodation for people that are part of the critical infrastructure. So, it's affecting all kinds of different licensed businesses, not just restaurants. And if you'll see the next slide, we can get into, all indoor recreational facilities must be closed. Museums, zoos, aquariums, movie theaters. Of course, wineries is a big deal here in Temecula. Bars, breweries, distilleries, family entertainment centers, card rooms, wagering, satellite, live sports, and amusement parks in particular were called out as businesses. And often many of these have alcohol licenses, and I've worked for almost every one of those as a on-sale retailer of alcohol. So they're all impacted by this order. They did have some sectors that have modifications that you can operate on a limited basis. But that I would make sure that even when we're operating under a limited business basis, we still have to have 100% masking, but that includes employees and customers and patrons, and physical distancing is what's required by the stay-at-home order. It's important to note, here's some more that was covered in the stay-at-home order. These are the exceptions. You have the retail outdoor exception for 20% capacity. And it's important to note that you can't have any eating or drinking while somebody is waiting for takeout. That's important to note. And indoor retail, if you have a retail shop and takeout food, you can't allow people to eat or drink inside the facility while they're shopping in any case. So if you're a combination retail and a restaurant or food provider like a deli, you cannot allow anybody to eat inside, even while they're waiting to take out any order or anything like that. It was interesting, the original order included grocery stores at 20%, and they did do a secondary amendment to the order to allow standalone grocery stores to go up to a 35% capacity. I haven't noticed any grocery stores counting in the area of how many people are in their store based on their fire department's occupancy limits. Maybe they have, but I was in Vaughn's yesterday or the day before, and I didn't notice anybody taking counts of that 35% occupancy, but it is in place. Of course, shopping centers is similarly, they are at 20% capacity, and they can have no eating or drinking while people are shopping in the stores because they want to keep people's masks on. This is additional, and the important thing is restaurants are allowed for takeout and pickup. I do want to talk about what you can do more first, is what is clearly allowed under the current order, and then what can we do after that. So what can we do for restaurants? Under the order, restaurants are licensed, may exercise their off-sale privileges. And typically restaurants have off-sale packaged beer and wine license privileges for both a beer and wine license type 41 or a liquor license of on-sale general eating place license type 47. Even in good times, non-COVID, you can sell packaged beer and wine to go unless you have conditions on your license that prohibit it. Now, during COVID, the ABC has granted special relief to on-sale establishments to broaden their off-sale privileges. One of the things they've done is now if you have a full liquor license, you can sell beer, wine, and packaged beer, wine, and spirits to go, just like a liquor store. So that's one of the things you can definitely do. You may also, if you have a full liquor license, sell cocktails to go, which includes containers of beer, wine, or distilled spirits mixed drinks. So if you're doing micheladas, you can put one of those, and you have to package it with a lid that is considered a sealed container. And you can even fill growlers now. So if you have glass containers, they're called growlers. They're a little half-gallon, 32-ounce, different size growlers. A customer can come in, or you can sell them, and you can put it right on your tap. You can fill it up with their favorite beer, put a cap on it, their cider, or whatever you have on tap, even wine on tap. You can do any of that and fill it and sell that to go as well. Now, beer and wine licensees can do the same with extent to beer and wine. Of course, if you only have a beer and wine license, you cannot sell distilled spirits to go. But it is one of the things they are allowing people to do with special relief. Once COVID is over, which we'd all like to return to normal, the ABC will eventually rescind these special grants, and we'll have to see if the legislature decides to pick up and pass legislation that would allow restaurants to continue selling cocktails to go, or restaurants to continue filling growlers. But until such time as the relief is granted, you can continue to do so. Now, bars, breweries, and wineries and distilleries. Okay. There, you still can exercise your off-sale privileges that you're normally allowed to do. If you're a winery or a distillery or a brewery that has a bona fide eating place inside of it, you can do cocktails to go similar to restaurants. The ABC has decided to treat even bars, that anybody who has food to go like a restaurant is acting like a restaurant in this times, can also do the similar things. They can fill growlers, they can sell cocktails to go. However, if you don't have food to go, like a bar that's just a pure bar, has not contracted with a restaurant next door to provide food service and meals to go as part of their ongoing program, all you can do is sell packaged alcoholic beverages, prepackaged manufacturer, just like a liquor store could. So if questions come up on this, I did put a complex chart together that's coming up on the next slide that has a lot of notes, and it has your license type, and it talks about the 3 different kinds of things you can do. Sell manufacture prepackaged things for to go, delivery or ship. And I wanted to let you know you can ship wine. So if a customer wants to order, they're in Northern California and they love the wine they had at your restaurant, and they call you up and said, will you send me a case of that wine? You can ship the wine to them. You can do delivery using both your own delivery drivers or third-party delivery services such as DoorDash, Grubhub, Postmates, or others. And you can or you can have people come and do pickup or to go. Finally, the second section talks about refilling containers. It talks about you can do beer growlers, wine growlers, depending on what type of license you have. And then finally, doing alcohol to go, like cups and sealed cup cocktails like micheladas or cocktails. You can do those to go if you sell it with a meal. And so it's important to do that. Now, you'll notice I had to put little notes here. So like a brewery that has a restaurant can do beer and wine to go if they have a restaurant, if it's sold with a meal. So if you have any questions about the chart or what you can do, my contact information will be at the end of the presentation, and we can go over that for your particular circumstance and make sure anything you want to do is we've discussed it and you're good to go. But I wanted to at least get to you on what you can do. Now, there's some things I want to caution you about if you're going to open for only off-sale privileges. One, customers are permitted on the licensed premises to purchase and pick up alcohol or beverage meals, but you're still subject to that 20% threshold. So you can only have 20% of your occupancy of people inside picking up orders. Secondly, you cannot serve people food and beverages while they're waiting for a to-go order. That was very common in the first part of COVID. And the ABC has come out and said, no, if you cannot have any on-site consumption within your business and be in compliance with the order. So some people are saying, oh yeah, I'm waiting for my takeout, but I'm just serving them a drink while they're waiting. They can't, that is not a workaround that the ABC will recognize as legitimate. And finally, I really want to caution people about third-party delivery companies and alcohol. The ABC, when this first came out in March, in May, we're getting complaints about delivery services serving minors. So they ran a sting program, and they found that 70+% of the drivers would deliver alcoholic beverages to minors without checking ID. So they had a 70% failure rate. So they contacted the major delivery services and said, hey, we have a problem here. You need to fix this. Well, after they did a month of education on it, they ran the stings again, and they still had a 53% success rate of alcohol being delivered to minors by these delivery services. So they were upset about it. So they went and passed emergency orders and allows them to run stings against companies that are serving alcohol, that are delivering alcohol. And the only problem is that the ABC can only punish a licensee. They have no control over the delivery company. So it's the licensee's license who's responsible when you're using delivery of alcohol. So they ran the stings again, and they give some licensees some warnings. Now, as of last month, they are now sending accusations and filing accusations against some of these companies that use delivery services. And like, I had a client in San Diego, they had used a delivery service and they delivered to a minor in August. They came by and got a notice from the ABC. The ABC has now filed an accusation for them serving to a minor because the delivery driver for the agency did not check the ID when they made the delivery of the alcohol. So it is a big issue right now. So if you are using a delivery service to deliver alcohol to your customers, I recommend you do the following. One, create a log for delivery drivers to acknowledge that when they pick up an order, that there's alcohol in that order. You write down the order, maybe the delivery number, and have them at least initial next to that order that they recognize alcohol is in it and they're supposed to check the ID. Two, I would staple a neon or sticker, a big giant sticker or a big thing over the top of the bag that's very, very visible that says delivery driver. This package contains alcoholic beverages. Please check ID before completing delivery. As a prompt to the delivery driver, as another additional effort that shows that you were trying to get the delivery driver to do the right thing and check ID. It might serve as a mitigating factor if the ABC is considering filing an accusation against you. If you show that you prompted the driver at the restaurant and informed him and he initialed that he knew that there was alcohol in there, and then two, had a thing on the bag prompting him to check the ID at the time of delivery, you've at least gone beyond what most licensees are doing to try and comply with the statute. So it's super important to me to do that. Let's see, I'm seeing some questions here. Yes, I'm going to get into the enforcement in a second here. And I'll answer, there's some questions about them identifying themselves. There is a question, are you ABC agents required to identify themselves if they're asked if they're an ABC agent? And the answer is no. They are just like undercover police officers. They are sworn officers. They carry guns. They're state police officers, just like a highway patrolman. And they do not have to identify themselves when they're working in an undercover capacity as an ABC agent. I did see the judge's court order, and I'll get into that in a minute, with the injunction yesterday. Right now, that's only applying to San Diego, and I'll get into that with you in a second. So I wanted to talk about, well, if I go ahead and decide that I'm going to go on and not comply with the stay-at-home order, what happens to me? That's what, everybody's asking me. That's the $1 million question. What is going to happen if I decide to ignore the order and stay open? Well, I want to talk about the 3 types of liability and what could possibly happen to you. The ABC can cite both you criminally for violating a misdemeanor, for violating the order. And it can be a criminal charge. They can also go after you on administrative liability. Civil liability is not something the ABC enforces. That would be something you have to think about when you're open. What happens if a COVID breakout is attributed to your restaurant? The civil liability could be extensive. We're not sure where that all is going to go. And so I'll leave that to the civil attorneys to advise you guys on that. But when an ABC agent is in there, they do 2 things. They can cite you criminally as a misdemeanor, and then that criminal citation would be forwarded to the Riverside County District Attorney, and the district attorney would have to decide if he wishes to prosecute or drop the charges. Those criminal citations will be prosecuted by the local district attorney. I don't know what Riverside County's district attorney's position is on, if the ABC were, or any law enforcement agency was to cite a business for remaining open as a misdemeanor. And that, is yet to be seen. Obviously, we've had our sheriff say that he has no intention of enforcing this. That obviously that he doesn't have any control over ABC officers, but I don't know if the ABC would actually cite criminally or not. But if so, that would go on to the DA for Riverside County and his position on whether he'll prosecute the case or not. Now, as for administrative liability, that's where ABC really has its teeth. And they have a range of enforcement options to them when they cite somebody for breaking what they feel is the state law. First, they can issue a warning letter. And that's what I've been advised by ABC's executive staff, that their initial approach is to get people to voluntarily come into compliance. They want people to do the right thing. They don't really want to be heavy-handed in this approach. They do want to get compliance voluntarily, and their initial stance is they're going to issue warnings, is what I have been told by their team. Now, that doesn't mean they're limited to only issuing warnings. If there's something that's super egregious that they feel is creating a major public health issue, you're throwing a rave in, you're having live entertainment, you have wall-to-wall people in your establishment, none of your staff is wearing COVID protection PPE, your customers are not being socially distanced within it, you're operating inside, you're doing everything counter to what it requires of the order, then they may come down on you harsher than just giving you a warning, because you're just being blatantly disregarding the law as they see it and the orders that have been published. So they can, as a result, they can file an accusation against your license. When they file an accusation, it's usually in terms of the suspension. They will seek usually anywhere from 5 to 45-day suspension. I would expect that in most cases, they would probably seek a 15-day suspension of your license. And then that allows you to pay an offer and compromise, which is a fine in lieu of taking the suspension. And those fines could range anywhere from $750 to $3,000. Obviously, if somebody was just egregiously, disregarding their orders, they've been warned multiple times not to do something, they continue to do something that they feel is incredibly unsafe to the public, they can go after a revocation of a license. Early on, there was a case in Fresno I was consulting on where a guy had a restaurant that had a bunch of roll-up doors. He continued to stay open and serve inside when we were in the complete shutdown order. He was warned by the city multiple times. He refused to come into compliance. The ABC finally got involved, warned him multiple times. He refused to come into compliance. They did file a revocation action against his license. I don't know the outcome of that case. I thought it was very draconian that they went that far, but they did get really aggressive with that one guy. But I think he was very public in the area in his vocal saying, I won't comply. And that's where I think somewhat Temecula has made a little bit of a mistake. I am aware that the ABC was out last weekend in downtown, I was told. I haven't gotten it from the ABC itself, but I have been advised by some of the local business owners that they were out there. They did warn a couple of establishments, but Temecula has been very vocal on the news. I've read multiple articles, news accounts, Fox News, stating that they're out there, that Temecula, a lot of Temecula restaurants, especially in the Old Town area, were going to not comply with the order. Well, when you're that vocal, you're just asking the ABC to come out. I mean, they really are only kind of enforcing this on complaint-driven basis, and or if they're, getting a lot of publicity about a particular location. So one of the things I suggest you do is, if you do decide, and I'm not recommending anybody avoid the order. I want to be careful that I'm not telling people to avoid the order at all. If you are going to ignore the order, that you not be very public about it. I would not be on my Instagram pages, my social media. I would not be commenting to to the PD, I mean, to the press about what your intentions are. I mean, I wouldn't even put out that you're open on your web pages. If people come and you're open, that's one thing, but I would be very, very discreet about what I'm doing, and not try and call attention to myself that I was, flagrantly violating the stay-at-home order. Can we move on to the next slide, please? Okay, what helps and hurts? And this is one of the mitigation and aggravating factors. When the ABC is looking at what they're going to do with you, should you violate the stay-at-home order or any ABC violation, they tend to take these factors into consideration. First, mitigating factors may include, but are not limited to, how long have you been open without any ABC violations? Have you a long history of being a good operator? That always is significant to them. If you've been in business for 30 years and never had a violation, they look at that and they say, look, this guy's had a really good, clean track record for many years, hasn't had any issues. But if you've been a problem place for them and they've already filed 2 accusations for selling to minor, they've had a disorderly house case against you where you haven't been very responsive to them, well, they're going to take that into account, whether they're going to want to go after a 15-day suspension, a 5-day suspension, or even revocation of your license. How you interact with the ABC, should they contact you about that, tells a lot. If they ask you to close and then you comply, I doubt that they're going to seek a suspension of your license. If they've come and talked to you multiple times and you're belligerent with them, you're dismissive with them, well, of course, like any police law enforcement agency, the more dismissive that you are of them, the greater and more aggressive they tend to become to get you to comply with the law as they see it. They're charged, they feel, with enforcing the law. They work for the governor. I mean, they don't want to be overhanded, but if somebody is really being super belligerent with them, they will, puff up their chest and, get more aggressive to get you to comply because they feel that that law is required for them to do it, to enforce the law. That's their responsibility. If you've done training and you're following COVID protocols and they show up to your place and you're only serving on a patio and you only have a couple of guests and they're all socially distanced versus the opposite, they show up to your place and it's a free-for-all inside, they're going to consider that and how they react to you. Those are things that'll come back. If you go right back one side, I was still working through that one, sorry. And then cooperation, how cooperative you are. Are you really cooperating with them? You're being responsive. If they ask for something, that's, what it, will turn out. I had a case earlier, I was just consulting on this last week, in which at the beginning of COVID, the bar had shut down. Then while they were shut down, the bartender had asked the owner, can I open and have a few of our regulars in and just really quiet kind of private party and use the space? And the owner, being a little bit naive, said, yeah, go ahead, as long as it's low key. I know you guys need to blow off some steam. You've been laid off, go ahead. Well, the employee got in there, held a crazy party. One of the patrons got, that was attending this little get together late at night, everybody was belligerently drunk, took a bar stool and started beating one of the other patrons. Then they threw him out into the parking lot and called an ambulance. And then all of that came back, and now the ABC is seeking revocation of their license. So, I mean, a little thing can turn into a big thing if it's not carefully watched. I'm ready to move on to the next slide. And then I'll get into your questions. All right, I've been watching and monitoring social media and hearing about different things that restaurateurs and businesses like ourselves are trying to do to find workarounds around the stay-at-home order. Somebody texted me yesterday that a place in El Dorado County was telling everybody that private clubs are allowed to stay open. So what they did is created a $1 membership at the door, and you can pay it and become a private club and come in and you can do everything around it. That is not true. If you look at the beginning of the presentation, the COVID order says that you can't socialize with people outside of your household. So going to a private club and converting to a private, quote, becoming a temporarily a private club is not a workaround that the ABC will recognize. Now, in Los Angeles, there is a movement right now to try and reclassify restaurants as essential. As you noticed at the beginning, the order said essential businesses can continue to operate, manufacturing, things that support grocery stores and such. And that movement is starting in LA right now. And I think that would be great if they could get the governor to recognize that and reclassify restaurants as essential. And so I think that is a potential for you to be able to, eventually, I don't know if it's going to gain enough traction to actually get where we want. But as more pressure, especially out of the courts, come that they have to have evidence to shut down. That was what was a lot of the ruling that came out of San Diego yesterday, was, the government is having trouble presenting any evidence that restaurants that are operating under COVID protocols outdoors is actually relating to any kind of tangible amount of COVID spread. And since the government is lacking some of that evidence, the courts are starting to side with the restaurants. There was a ruling out of LA that struck down kind of an LA ban, but then the governor came in with their public health order that kind of trumped that. Now there's a court in San Diego County that has enjoined the government from enforcing the shutdown of restaurants in San Diego County. Of course, we don't know if that ruling is going to be appealed and what the results are. But right now, of course, that is only for San Diego County because that Superior Court only has jurisdiction for that county. So to answer the question earlier, we're in Riverside County. The Riverside County Court hasn't ruled on it yet. So that right now is only applicable to San Diego County. Now, I have seen some clever restaurateurs create public protest area outdoor. And they basically, you know how we've all been creating these parklets outside to accommodate that. They didn't go for a COVID temporary permit. I know many of you got COVID temporary permits to expand your restaurants to cover like an outdoor seating area. They basically removed that COVID permit from the outdoor seating area, put tables and chairs out there and said, well, that's a public protest area. And if people went and got to-go orders and sat out in the public protest area, they were protesting by sitting there. And as you saw at the beginning of the COVID order, public protests are allowed under it. So it's a gray area. I'm asking some attorneys I know to weigh in that are more knowledgeable on this particular aspect of the law, on freedom of expression and speech, and I'm waiting to see what they come back to me on. But I thought it was a clever idea, and I'm waiting to get a little more on it. Now, one of the last ones, public parklets and suspension of open container ordinance. Right now, the city of Manhattan Beach has just passed, and they took all those parklets that, like, if you would have seen them on Front Street, the little eating areas, and they said they had everybody, they revoked all the COVID permits and said nobody has an outdoor COVID permit. But what we do is make these all public eating places, space. And so though it's no longer covered by the license, the only problem is in Manhattan Beach, they prohibited alcohol. Well, I'm being heard that Dana Point and a couple other cities in Orange County are considering, and I thought I was trying to verify which city did, suspending their open container ordinance in their certain areas of the city. So in essence, if you combine the parklets with a suspension of the open container ordinance, customers could come up to your restaurant, get food to take out, cocktails to take out, and then, quote, go to the little parklet, which has now been defined as a public area, and there's no law against public consumption of alcohol, and sit there and eat and drink as a workaround the order. And honestly, I thought it was super clever. I think that if a city wanted to cooperate with restaurants and get behind it, I think the ABC would have little they could do to enforce it because the licensee hasn't violated anything. They sold alcohol to go. under what is permissible. And since it's not illegal to drink in public in that, zone or whatever, and that the public seating is there, I'm not sure that they could stop that. So those are some of the workarounds I'm seeing. Here's my contact information. I'm happy to answer questions now and kind of go through it with everyone. I do want to thank you for taking the time to join the SET webinar. Somebody asked, can guests take their food out to outdoor tables to picnic? And that's exactly what we were talking about when if your area outdoors is not covered under a COVID liquor license expansion, that's the protest area approach or the public parklet approach. And, I think, yes, people would be able to do that, would be my takeaway. Generally, at least the ABC wouldn't be able to enforce against you. Now, if they're serving alcohol in that area, that's another problem, because right now Temecula does have a no open container in public ordinance. When I first moved here back in '95, they didn't. But sometime subsequent to that, they did add that ordinance in. They would have to suspend it to allow public consumption of alcohol in order to not be able to be cited. At least your patrons would not be cited for drinking in public. The occupancy limits, I believe occupancy limits do include employees. I don't believe that you can. I think it's the occupancy within the building includes all individuals in the occupancy, not just patron occupancy. But I'm not a building official, so to get that answer cleared, you would have to definitely talk with the city of Temecula zoning officials. By the way, one other question was posed to me. A client said, well, what happens if I just stop selling alcohol and I don't sell alcohol anymore, but I allow people to come eat on my patio? If you wanted to take that approach where you didn't want to give ABC a chance to come after your license, the best way to do that is to temporarily surrender your license. We fill out a form, we surrender your license. At that point, you're basically an unlicensed premises. And if you were serving food out there, I don't think the ABC would have jurisdiction over you. I can confirm it. I do have a call into an ABC executive to confirm that. But if your license is officially surrendered, then you're no longer a licensed premises in the eyes of the ABC, and they would have very little enforcement action that they could take against you as long as you weren't serving alcohol. So I thought, there was one or two businesses that only sold a de minimis amount of beer and wine as part of their business model. And they were thinking about just going ahead and surrendering their license and then going ahead and serving food outdoors and taking basically the authority away from the ABC. I don't think that they would be able to prosecute a violation against you if you were no longer serving alcohol and your license was officially surrendered. Oh, sorry, somebody corrected me. The fire department occupancy is under the fire department's jurisdiction. Thank you for that input. And so you need to confirm with the fire official how they calculate the occupancy of a building. If I have a patio area, one question came up is, if I have a patio area on my licensed property, can I designate it as a public protest area? That's what somebody is, that's what they're doing in LA in some areas. Now, if that area is part of your licensed alcohol premises, the ABC, I'm not sure how the ABC is going to approach that issue because it is under their jurisdiction, but with a license, if you've notified it as a public protest area, if you're serving alcohol out there, it's going to be kind of one of these interpretation issues. I think they'll probably give you a warning on that issue because now you have a freedom of speech issue going on, and but you're doing it within the confines of a licensed premises. If the area is unlicensed, then I think you have a better chance of winning that case. But that would be something I would want to have you double check with an attorney before you started doing. Yes, if you surrender your license, you can reinstate it. As long as you have all the underlying permits are still valid that got you your license, yes, you can reinstate it at any point. We just go and file another form to reinstate your license. Up to a year, you have a chance up to a year to reinstate. Have you heard of ABC shutting off the ability to purchase from distributors? For example, you cannot go past 30 days of paying bills if you find yourself cut off until AR is current. No, the ABC is not, they can suspend your license, but they can't, that's the only way they can stop vendors from selling to you, is by actually suspending your license. They can't call up a vendor and say, well, this guy's breaking the COVID rules, you can't sell to him. Now, the 30-day rule doesn't mean your vendors can't sell to you if you've let your 30-day credit elapse. It just means they have to go cash on demand for any other purchases after the 30 days until your account is brought current. So you can still purchase from your wholesalers, you just have to pay cash upon delivery. Okay, what happens if in San Diego yesterday the courts affect us? Again, I mentioned that earlier in the conference, that it doesn't impact Riverside County yet because that ruling only is germane to San Diego County because that's where the Superior Court of San Diego is based. The Superior Court for Riverside hasn't ruled on it. So my understanding is that implication is only impacting San Diego County. Of course, that decision may be appealed, modified, we'll see. I would hope, it might become, especially if it's appealed and is upheld, then it obviously would cover a much broader area. If they suspend your license, what is the process to get your license? If they suspend your license, okay, the ABC, when they go to suspend your license, let's say you violated the law, they filed an accusation, and they have to go through a whole process. It's not like they can just walk in and say your license is suspended. They can only do that if there's a real emergency, like it's a real public health threat going on, you have a rave going on, and it's a danger to allow the place to continue to stay open. They're not, I confirmed with the ABC that they're not using that power in COVID situations. So if they do file an accusation, you have a right to go to an administrative law, have it reviewed, hearing, and then if the decision ultimately is to suspend your license, it'll be for a set number of days. They have to come out and post a suspension notice on your venue, and then you'd be closed the exact 15 days. You would know the days. And then at the end of that time frame, your license would be returned to you. I think in most cases, people would be paying fines in lieu of suspension, but I'm hoping that most of you won't even get that far down the road. Again, if the ABC has given you written warnings, I would take that seriously. But I believe that their general preference in COVID, as it's been expressed by their leadership to me, is to educate first, and then if they have to get more aggressive with their enforcement powers if they can't get compliance voluntarily. Okay, Be Good Restaurant, okay, has already designated outdoor tables as public spaces. They're selling takeout, including cocktails to go, that can be consumed at the public tables outside their restaurant. Well, the only thing that, doing that takeout and allowing people to drink in public, it isn't on the licensee. But at that point, if you didn't get a COVID expansion to serve alcohol and you're just doing alcohol as takeout to go, once it's left your restaurant, you're not necessarily responsible for it. But I wouldn't want you to be setting up a situation where your patrons could get a citation for violating the open container law. So I think it's important if the Old Town Restaurant Group or any of people want, Old Town, I understand there's an Old Town Merchants Association or such. If they approach the city, and it would be better to have the city suspend the open container law officially so that no one can be cited for drinking in public down there. That would be a better approach than leaving your potential customers open to a citation for drinking in public. Again, the San Diego order right now, as I'm understanding it, is the Attorney General of the state of California is not in, and the county are not enforcing within the borders of the San Diego County. I was going to talk to the representative for the California Restaurant Association in San Diego to find out what his take is, but to date, I believe that that only applies to San Diego. Repeating it. I mean, today overrule the judge. I don't know that anybody can overrule the judge's decision except an appellate court, but I'm not an expert on that case or on that. So I'll have to leave that to kind of wait and see what's coming out. My understanding is that some ABC, a question came up as ABC always giving written warnings or agents in person. I've tried to get confirmation on phone calls. I've understood, one of my clients told me yesterday that they got a purported call from the ABC saying that they shouldn't be serving alcohol in there. I did try and get confirmation from the ABC. I did, I'm trying to get their protocol. If they're going to be calling restaurateurs, how do they know that they're getting in touch with the right person as for the warning? And how do we know that it's an ABC representative making the phone call? And I've been trying to get some answers from the ABC. I can probably share it with the chamber once I have that answer, and she can share it out to the group. But as far as I'm aware, that they may be making phone calls, but they should be asking for the actually know the name of the owner that they're asking for, and it shouldn't be a generic phone call. I believe that the ABC would say, I'm agent so-and-so, and I'm attempting to contact either a listed officer of the company or a thing. They shouldn't be generically saying, can I talk to the owner? They should be looking for a specific person that's listed in their ABC file. And usually they have their direct phone number. So I would expect that that's how they're approaching that. I did call the division office for ABC, not the Riverside office, but the division office for all of Southern California yesterday to confirm that. Unfortunately, they're very low staffed in their ABC office. Even in the Riverside office, I called, and all of their executives in the Riverside office were out. All their leadership were not in yesterday. So I'm still trying to get confirmation on the phone calls. Is there any other questions I can answer for you? I hope that I've covered as much as I can. I am very hopeful about the San Diego ruling. I'm hoping that more courts will adopt that, or it'll get peeled so it's a broader interpretation on that. I want to thank you all for joining. If there's any questions you have my email here. Feel free to hit me up directly, and I'll keep you guys abreast of what I know when I know it. Thanks again.
Thank you so much, Michael. We appreciate it very much. And like you said earlier, I will be sending out a follow-up email with the video and your contact information and your slideshow and all of that. So thank you for all of your information, and everyone can also reach out to the chamber as well if you have any questions. Have a wonderful day. Thank you.
Happy holidays, everyone.